welcome to this Back to Basics presentation on the 4 rights of health and safety for workers, presented by CUPE and the Ontario School Board Council of Unions. My name is Michelle Lalonge Davey, OSBCU Health and Safety Representative, and I'm joined today by Mike Saliba, OSBCU Injured Worker Representative, and Paul Sylvestre, CUPE National Health and Safety Servicing Representative supporting our sector. We have developed this presentation to provide workers with a basic understanding of the rights workers have in the workplace. In light of the COVID-19 pandemic, the presentation will hopefully allow you to exercise these rights to ensure you and your co-workers are protected and to ensure compliance with the Occupational Health and Safety Act. So what will this webinar cover? First, we will speak briefly about the purpose of the Occupational Health and Safety Act and the regulations. Then we will find out what is meant by the internal responsibility system. And then we will go over exactly what are the 4 rights. What is the Occupational Health and Safety Act? The Act. It was first enacted in 1979 and then revised in 1990. The Act is the primary legislation for maintaining and promoting health and safety standards in the workplace. The Act sets out minimum workplace standards that must be met at all times. This is also called maintaining compliance with the Act. The Act sets out duties of persons in the workplace, including employers, supervisors, constructors, workers, owners, and others. Example, a duty of an employer is to provide training about workplace hazards and take every precaution reasonable in the circumstances to protect a worker from those hazards. A duty of a worker is to wear personal protective equipment, PPE, that the employer requires a worker to wear and to report to your supervisor any concern, hazard, or danger that you might have about your workplace. The Act sets out how violations are enforced. The Act describes how regulations under the Act are made. We will talk briefly about regulations in the upcoming slides. The Act is built on a philosophy called the internal responsibility system. And now Paul will talk about the internal responsibility system.
Here is a diagram that describes the Internal Responsibility System, or IRS. As you can note, workers and employers are on the same level. The IRS is a system where everyone has a shared responsibility for health and safety as an essential part of their job. While it is a shared responsibility, it is not an equal responsibility. Employers have the bulk of duties and responsibilities under the Act. For the IRS to be effective, employers, supervisors, workers, and other workplace parties need to have practical knowledge, training, and skills to eliminate or adequately control workplace hazards. If any one of the workplace parties is not fulfilling their duty, the IRS is not working. Where there is a failed IRS, there is non-compliance with the Act. And as a result, workers are more likely to encounter workplace incidents, accidents, and occupational illness. So over to Mike.
So what are regulations made under the Act? The Act sets out broad legal principles which apply to most workplaces. A regulation made under the Act sets out specific rules for certain workplaces, workers, and hazards. There are 26 regulations made under the Act. Regulations under the Act can define words, exempt workplaces, designate substances, restrict hazardous agents, and prohibit activities. Examples of regulations include the WHMIS regulation and the regulation that addresses asbestos in the workplace. So what are the 4 rights of a worker under the Act? Number 1, the right to know. Number 2, the right to participate. Number 3, the right to refuse dangerous work. And number 4, the right to know reprisals. Michelle?
The right to know. Every worker has the right to know about the hazards or dangers in the workplace and the hazards in their work. Employers must provide information and instruction to protect the worker. This means adequate training to do the job safely. Section 25(2)(a) represents where this right is located in the Act. Also, the employer must acquaint a worker with the hazards of the work and the hazards in the use, handling, storage, and disposal of chemical and biological agents or hazards. And you can find that under Section 25(2)(d) in the Act. This is an important right because COVID-19 is a new hazard in the workplace, and as such, we need to know about the likelihood of exposure to the virus and how to protect ourselves from exposure. The right to know includes the right to find out information about hazardous products. Under the WHMIS regulation, a worker who works with or may be exposed to a hazardous product, either chemical or biological, must receive information about the product. A worker must also be familiar with the contents of a supplier or workplace label and the contents of a safety data sheet. Additionally, a worker must receive training on workplace health and safety policies and procedures before undertaking the work. This includes policies and procedures around violence, harassment, personal protective equipment, and infection control and prevention of biological hazards. I'll pass it back to Paul.
What is the right to know about workplace violence and harassment? An employer shall provide information to a worker about a person in the workplace with a history of violence if the worker is likely to encounter that person in the course of their work and the risk of exposure is likely to cause physical injury. This can include personal information about the person with a history of violence. An employer must also provide training to workers on how to recognize an incident of workplace violence or workplace harassment, how to file a complaint, and how the employer will investigate incidents of workplace violence or harassment. If a worker has filed a complaint of workplace harassment, the employer shall provide the worker in writing the results of the investigation and if any action has or will take place as a result of the investigation. So how can we exercise our right to know during the COVID-19 pandemic? The first thing, do you know the contents of the school board's pandemic plan? Do you know about COVID-19 workplace plans? Do you know about your job-specific plan to return to work safely and the hazards of COVID-19? Have you received information on the modes of transmission of the virus in a school setting and how to protect yourself? Does the plan include physical distancing and the use of barriers? Does the plan speak about who can work from home and what are the travel limitations between school or within a school? Does the plan speak about student and staff cohorts? There should be a section about cleaning, disinfecting, and personal hygiene. And the plan should also talk about screening before entering the workplace and how to self-assess for symptoms of COVID-19. Does the plan speak on the use of personal protective equipment and when it is necessary to put specific equipment on? Does the plan speak about how contact tracing will take place in the event of exposure and if any testing is required as a result of possible exposure? Finally, have you received training and instruction about your job-specific plan? If you have any concerns about the plan, it is your duty under the Act to inform your supervisor of any gaps or dangers in the plans that may leave you exposed. I'll pass that along now to Mike.
Now we will talk about the right to participate. The key to a functioning internal responsibility system is an ongoing assessment of the workplace health and safety system. A health and safety representative, or HSR, and a joint health and safety committee, also called the JHSC, plays an essential role in the assessment of the system. So why do we have health and safety representatives or a joint health and safety committee? Under the Act, the main function of a health and safety representative or committee is to identify any workplace hazards or dangers. The representative or the committee has the power to obtain from the employer information about the workplace hazards and dangers. Once the information about the hazards is obtained, the health and safety representative or the committee has the power to make recommendations to improve workplace safety. Let's briefly talk about the difference between a health and safety representative and joint health and safety committee. A health and safety representative is required at a workplace where between 5 and 19 workers are regularly employed. A joint health and safety committee is required at a workplace where 20 or more workers are regularly employed. Both the health and safety representative and the joint health and safety committee have similar powers and functions under the Act, except that a health and safety representative does not have meetings with the employer. In school boards, there are very few health and safety representatives, but there are two different types of committees that we will be discussing later. Michelle?
Now we will talk about the Joint Health and Safety Committee representation and requirements under the Act. A workplace with 20 to 49 workers must have a committee with at least one worker representative and at least one management representative. A workplace with 50 or more workers must have at least 4 members on the committee. At no time can the management members on the committee outnumber the number of worker members. The worker members of the Joint Health and Safety Committee are selected by the union, or if there is more than one union in the workplace, it is selected by the unions. It's important to note that a collective agreement or terms of reference for the committee can expand these requirements by having more workers sit on a committee than the minimum standard of the Act. There are 2 types of committees that you might find at a school board. They are called single site committees or a multi-site committee. Where so permitted by the Ministry of Labor, a multi-site committee may be established. In this case, one committee can be established for all the schools and workplaces in the board instead of having a single committee at each school or site. The multi-site committee members have the same rights and duties of a single site committee. If a worker member of the multi-site committee does not inspect the workplace monthly, a worker from the workplace is designated to inspect the workplace. Over to you, Paul.
Now we will briefly go over the functions and powers of a joint health and safety committee and a health and safety representative. Representatives and committees inspect the workplace at least once monthly. They also investigate workplace incidents, including work refusals, critical injuries, or fatalities. They review notices of workplace accidents and occupational injuries. They can obtain information from the employer about the conducting of a test in the workplace and be present at the beginning of testing. And they can obtain information about workplace standards in similar workplaces. In terms of COVID-19, it is essential that the committee or representative obtains as much information possible about the school board's reopening plan. They are permitted to receive information about the plan so that they can make recommendations to improve any potential gaps in the plans or situations that might put a worker at a greater risk of exposure to COVID-19. If you are unsure about who is the committee member in your school, the Act says that their names must be posted in the workplace and is usually on the Health and Safety Board. We will now move on to the right to refuse work where health and safety is in danger. Every worker under the Act has the right to refuse work if they believe their health and safety is in danger. The right to refuse work is to be used when the internal responsibility system has failed and a situation is likely to endanger the worker's health and safety. Certain workers in healthcare and developmental services must meet a criteria before exercising their right. Where a worker is refusing to work because of health and safety, it is important to remember that it is an individual process and that every circumstance will be different. Here are some circumstances that would meet the criteria to refuse unsafe work. Please remember that this is not an exhaustive list, and that if at any time you feel as if your health and safety is in danger, you can engage the right to refuse process. You can refuse if you are asked to perform a task without adequate training, and the task is likely to endanger health and safety. For example, if you have not had training on COVID-19 and a task you are to perform will likely put you in danger of exposure to the virus. If you're asked to perform a task alone, where 2 or more workers are normally required to perform the task safely. You're asked to perform, to work with a student with a history of violent behavior without an adequate safety plan or a notice of the risks of workplace violence. You're asked to perform a task that requires you to wear PPE for the first time and you haven't received training on the care, use, and limitations of the equipment. You're asked to perform a task using faulty, damaged, or improperly guarded equipment, machinery, a device, or thing. Or if you're asked to perform a task that is in contravention of the act or the regulation, and the task is likely to endanger your health and safety. Mike?
So, we will now go through the process of exercising your right to refuse. Step 1, communicate the danger immediately to a supervisor, or in the case of the school, a principal. Supervisor or principal must then investigate the circumstances of the work refusal in the presence of the refusing worker and a member of the Joint Health and Safety Committee or the Health and Safety representative. Awaiting the investigation by the supervisor, no worker can be assigned the task that is being investigated. The refusing worker is to remain in a safe place near their workstation and should be available to answer any questions about the work refusal. Once the supervisor completes the investigation, the worker will return to work if they are satisfied with the outcome of the investigation. However, if they are not satisfied with the outcome of the investigation and any steps that may have been taken, the worker can continue to refuse the work if they have reasonable grounds to believe that the work is still a danger to their health and safety. We then move on to the second step of the process. If a worker continues to refuse after the first step of investigation, an inspector from the Ministry of Labor is called in to investigate the circumstances of the work refusal. The call can be made by either the supervisor or the worker member of the Joint Health and Safety Committee, or the worker that is refusing. Awaiting the completion of the investigation by the inspector, the refusing worker can be assigned reasonable alternative work. This means that the worker cannot be assigned work that is considered to be punitive for having refused work. Until the investigation is completed by the inspector, no other worker is assigned the task being investigated unless the oncoming worker has been advised of the refusal and the reasons for the refusal. The oncoming worker is advised in the presence of a Joint Health and Safety Committee member. The oncoming worker has the right to refuse as well. The inspector, upon completion of the investigation, will provide a written decision if reasonable grounds exist for the work refusal and if any corrective action will take place before work can resume. Once a written decision is rendered, and if the inspector finds no danger exists, the worker must return to work. In some circumstances, the inspector will not find reasonable grounds for a refusal, but will investigate the situation as a complaint to determine if there is a violation of the Health and Safety Act. The decision of an inspector can be appealed within 30 days if there is a disagreement about whether or not there are grounds for refusal or if there is a violation of the Act. Nevertheless, the worker shall suffer no reprisal for exercising in good faith their right to refuse dangerous work. So now we move on to our final right, which is the right to no reprisals. Michelle?
First of all, it is important to know what is a reprisal. Here are examples of a reprisal under the Act. No employer or person acting on behalf of an employer shall dismiss or threaten to dismiss a worker, discipline or suspend or threaten to discipline or suspend a worker, impose any penalty upon a worker, or intimidate or coerce a worker for exercising a right or duty under the Act, performing a function or exercising a power as a member of a joint health and safety committee or as a health and safety representative, seeking enforcement of the Act. An example of this would be calling a Ministry of Labor inspector, providing evidence at a labor board hearing, like an appeal or at a coroner's inquest. In summary, you cannot be disciplined for complying with the Act or for raising issues of health and safety in the workplace. The reason for this is to ensure that workers always feel comfortable raising an issue without fear any negative action is taken against them. If you believe that you have suffered a reprisal under the Act, it is important to communicate immediately with your local or a steward. The local may choose to file a grievance or file a complaint with the labor board. Often the filing of a grievance will resolve the issue quicker than going to the labor board, and it is the preferred method for unions to resolve a reprisal complaint. Paul, back to you.
If you are looking for more information about the Occupational Health and Safety Act or your rights under the Act, we invite you to go to CUPE National's Health and Safety page and the CUPE National COVID-19 page, which has information on how to protect yourself from exposure to COVID-19. CUPE Ontario also has a COVID-19 webpage. There are also lots of resources and fact sheets available at cupe.ca/health-and-safety. We are also recommending visiting the Workers' Health and Safety Centre webpage or the Canadian Centre for Occupational Health and Safety webpage, or the Occupational Health Clinics for Ontario Workers webpage. You can also find information about your rights and duties under the Act at the Ontario Ministry of Labor's Health and Safety page. Of course, you are always encouraged to contact your local or talk to a member of the Joint Health and Safety Committee at your workplace. Who can I contact with questions? Your local president and executive members, a worker member of the Joint Health and Safety Committee, Michelle Lalonge-Davy, Mike Saliba. Thank you for spending time with us today, and be safe.